I'm Jim Gordon at Beers and Gordon. After an accident, sometimes your life is upended. You know, you're doing your regular thing, you're going to the gym and working out, you're going to work, everything's fine, you're living your life, you're going to your kids' soccer games, you're playing with your kids at home, and then you have an accident and everything changes. You can't go to the gym because you're in too much pain. You can't lift your kids or play with them or get on the floor and play Legos with them. You can't coach their games. That is what's called loss of enjoyment of life, or what we call pain and suffering. And that's one of the biggest components of damages in any case. And that's one of the things we're looking at in the case, is what is the pain and suffering of the person. In fact, before we even put out a demand, we actually have a questionnaire that goes out to all of our clients that asks them with prompts to answer questions about what limitations they've had in their life. Sometimes they get better and they don't have any limitations and we don't make a pain and suffering claim. But that's an important part of the case, because it also tells the insurance company, and tells, if we're in litigation, what the actual individual's issues are, because they're different in every case, wouldn't you say?
Yes, definitely. The pain and suffering as an element of damage has been recognized in Florida, since the beginning of common law in Florida. But what the effect is on the individual is not specified, so that it can be mental anguish, it can be inconvenience, and it can be physical pain and suffering that requires medication, for example, to compensate one of our clients.
And it's the element of damages that is basically undetermined. Your medical expenses, we could say your medical expenses are $25,000. And we can have a doctor say, this is what we're going to need in future medical expenses, and we can look at that. The jury instruction said there's no formula to determine what pain and suffering is.
So it is up to the jury, and that's why you need an experienced team, such as we have at Beers and Gordon, to help you develop the case so that you get the compensation you're entitled to receive for pain and suffering.
And we tell clients all the time, you don't want to sit in litigation, you don't want to sit in there and whine about everything under the sun, because that doesn't look good. But there is an importance, and that's the part of the preparation we go through in deposition prep, is make sure you get all that information out there. And we actually tell our clients, go back and go through a list of what you can't do at all and can't do as well, and know that list. So when you sit in front of another attorney, you're telling them everything that's changed in your life. And like you said, that can be a mental change, that can be a physical change. We see clients that can't sleep anymore, or they have trouble getting to sleep, or they get woken up. I know a lot of times when people are parents, it really affects the relationship, especially if they have small kids and they can't carry them anymore, and various things like that. And that's why it's important to go with someone that's going to work with you and going to know you and know your case. Because if we know you and we work with you, instead of just one of our assistants talking to you occasionally, and you're just a number at that firm and they have 500 other cases at that firm. But when we know you and we talk to you and we listen to you, and that's the other thing, we're going to listen and know what your issues are.
And I think pain and suffering is a very important component in any personal injury case. And if we don't begin, and our team doesn't begin right from the outset of the case, developing the facts that support the pain and suffering claim, we just won't achieve the best result we can.
And those are arguments we're making throughout the case, whether it's at the demand stage, where we ask for pain and suffering and we explain to the insurance rep, what that means. But it also becomes a very important element once you're in litigation. And in a lot of ways, it's the most important element in front of the jury, because they have to understand what changes have been occurring in your life. And we want to show, this is how you were before the accident, this is how you were after the accident. And sometimes many times we use witnesses to do that. We're called before and after witnesses to say, this is, it could be a spouse, it could be a best friend, it could be a parent, whatever. This is how they were before, and this is the changes after. And those are important factors at trial.
And in presenting pain and suffering, it's also important to have an experienced lawyer working with the doctors, because some doctors are not going to be much of a patient advocate. Whereas in our experience, because we're not a mill, we're not a large firm, because we're able to communicate with the doctors on a little more of a one-to-one basis, we can assist the doctor understand how important it is to be a patient advocate for our clients so that they do achieve the best outcome in pain and suffering damages.
And that's important because in Florida, the way the law is written is you don't get pain and suffering damages if your injury is not permanent. So we have cases where the injury is not permanent. They're young, they get better, the doctor says they get better, and we can't do anything beyond the economic damages. But if they are permanently injured, that's when we're working with the doctors, and then we're presenting that case for pain and suffering, because a lot of times that is the biggest element of damages we can present, and that's going to be the biggest chance you have to recover above and beyond your economic damages, repaying your medical expenses, are those pain and suffering damages. What a permanent injury, a lot of times from a doctor's perspective is what they say is it's a permanent anatomical change. So the easiest thing, the way to describe it is if you had an accident and you broke your leg and you had a rod put in your leg, that's a permanent anatomical change to your leg. That's a pretty easy, I mean, it's the easiest one we say to explain to a jury. They don't really have to understand what they're seeing because they can see the rod in the leg, and we can say that's where the injury is, number one, but that's where the permanent injury, number two, is. Other examples of permanent injuries are herniated discs can be permanent, bulging discs can be permanent, and a lot of times it comes down to the person. And some people have herniated discs and they feel fine, and some don't, and that's where it becomes, we have to know the case as attorneys, and the doctor has to understand the injury. And that's why it's important to go to a good doctor.
Right. I mean, the guide to the evaluation of permanent impairment put out by the American Medical Association tries to help doctors determine whether or not someone has a permanent impairment. And to do that, one of the bases is whether they have a continuation of subjective pain complaints that can be documented as in a clinical setting as having been caused by a traumatic accident. But the pain complaints have to last at least 6 months. And there has to be some sort of objective evidence of the condition that is creating the pain. So you can have doctors who say, for example, I've had doctors in the past say, well, your client had a mid-shaft fracture of the clavicle right here. It's what's referred to as a green stick fracture in the mid-shaft of the clavicle. And that knitted together, no casting, no rod, that knitted together, that union of that bone, David, is just as good anatomically as it was before the crash. So therefore, my opinion as a doctor would be, I can't give you any anatomical change. And I've argued with doctors and said, wait a minute. That is not the same clavicle that God gave my client. That is a clavicle that had a fracture and has healed the way God wanted the clavicle to heal, but it is not the same. And so that is a permanent anatomical change. And these are the subtle distinctions that it's important that your attorney would know to be able to recover for you by being able to establish a permanent injury so you can recover pain and suffering.
And I know that's a frustration I have, is when I see attorneys that don't have experience, they don't frankly know what they're doing, and they get a doctor say someone's permanently injured and they give them a 1 or 2% impairment rating because that's what the guides tell them to do,
right.
And that's what the guides said. They don't have to have that. All the doctor has to say is the injury is permanent. They don't have to put a percentage on it. So why do that? And if we have that situation, we just tell the doctors we don't need the percentages. In fact, we never ask for a percentage because it's irrelevant. And all we have to prove in front of a jury is, was injury permanent or not?
Exactly.
So it's important that you look at experienced attorneys that have handled pain and suffering damages on both sides of the law. And that's what we've done at Beers & Gordon. So if you have questions about your case, please give us a call at Beers & Gordon Law, 407-862-1825, or visit our website, beersandgordonlaw.com.